When is an abortion not an abortion? When a liberal judge says so. Dan O'Donnell here with the McIver Institute, and Dane County Circuit Court Judge Diane Schlipper employed some, well, Schlippery logic to claim Wisconsin's law banning all abortions in the state doesn't actually ban abortions at all. Instead, she claims it deals with feticide, which is the killing of an unborn child. Abortion, of course, is also the killing of an unborn child, but that's beside the point. For Schlipper, who just wanted an excuse to invalidate the law, there's apparently a big difference. And she is technically right, but unfortunately for her, Wisconsin's abortion law itself delineates between the two. The law, which opponents like Schlipper absolutely have to call the 1849 law every time they refer to it, is in fact Wisconsin Statute 940.04. It's conveniently titled abortion, in case there is any doubt as to what it deals with, but Schlipper disagrees. And here's where she's wrong. It is true that 940.04 Section 2 deals with feticide, but 940.04 Section 1 criminalizes abortion. Any person other than the mother who intentionally destroys the life of an unborn child is guilty of a Class H felony. That's an abortion. 940.042 describes a completely different act, and that's why it's punished more severely. Someone guilty of it faces a Class E felony, not a Class H felony, and is subject to harsher penalties. But Schlipper thinks all this is moot because of another abortion statute currently on the books, 940.15, which criminalizes abortions only after the fetus reaches viability. She claims that when this statute was enacted, the legislature engaged in what's known as the implied repeal of the older abortion law. The problem with this is that implied repeal is a disfavored legal doctrine. If the legislature really wanted to repeal the 1849 law, it had more than 170 years to do so, but it never did, even when it enacted the new statute as a way of complying with the Roe v. Wade and Planned Parenthood v. Casey U.S. Supreme Court decisions. So what's the status of abortions in Wisconsin now? They're still illegal. Judge Schlipper didn't issue an injunction against enforcement of the older statute, so it's still in place. Ultimately, the Supreme Court will decide if it should be struck down, and given its current liberal bent, the court almost certainly will, on whatever flimsy grounds it can think of. Judge Schlipper's ruling should thus be instructive because it illustrates how liberal judges creatively interpret laws to say anything they want them to, including that criminalizing abortions doesn't really mean criminalizing abortions. For the McIver Institute, I'm Dan O'Donnell.